Now I am going to dictate a legal passage based on latest judgment of the Kolkata High Court at the rate of 120 words per minute. Let's start. It appears that the respondents herein preferred an application under the provisions of Order 7, Rule 11 of the CPC, stating that the eviction petition number 136 of 2001 was barred by the principle of res judicata and the plaintiff be rejected accordingly. The additional rent controller declined to reject the plaintiff ID order dated 23/07/2002. The additional rent controller, while rejecting the application filed by the respondents for rejecting of the plaintiff, took the view that the second eviction petition filed under Section 14 (1) a of the Act 1958 was based on a fresh notice dated 18/05/2001 on separate cause of action, and that there was no finding on merits as regards the relationship of landlord and tenant between the parties in the order dated 27/01/1998 referred to above. The additional rent controller in such circumstances took the view that the plea of res judicata was not tenable in law. The application under Order 7, Rule 11 (d) of the CPC was accordingly rejected. The respondents herein being dissatisfied with the order passed by the additional rent controller challenged the same by filing the civil revision petition number 1332 of 2002 in the High Court of Delhi. The High Court allowed the civil revision petition and rejected the plaintiff of the eviction petition number 136 of 2001 on the ground that the same was hit by the principles of res judicata. The High Court, while allowing the civil revision petition filed by the respondents herein, observed as under. In the present case in hand, as Singh, the predecessor in interest of the respondents of the landlords, failed to produce any evidence to establish the relationship of landlord and tenant between the parties in the first eviction petition filed by him under Section 14 (1) a of the Act, as the said decision was not taken in appeal by any of the parties. The same attained finality, having been afforded an opportunity to lead evidence and having failed to produce any evidence in the court. It has to be taken as a decision on merits under Order 17, Rule 3 of the Code of Civil Procedure for the purpose of Section 11 of the Code. By filing a subsequent eviction petition, the respondents cannot be permitted to do directly what they could not do indirectly. Failure to adduce evidence resulting in dismissal of the claim of the respondents for want of proof is in reality a decision on merits, just as if the petitioner therein had produced evidence which the court had considered as inadequate proof and had dismissed it upon the said ground. Applicable to such a situation is that legal maxim de non apparentibus et non existentibus idem est ratio. It is a rule which applies to those things which do not appear and to things which do not exist. So, for maintaining his right to claim arrears of rent, if S. Singh was required to prove that he was the landlord of the petitioner but he failed to do so, the rent controller had no option but to decide the issue against him on account of non-production of evidence. In other words, what does not appear must be regarded as non-existent. In these circumstances, the decision of the rent controller dated 27/01/1998 has to be taken as a decision on the merits of the matter merely because a subsequent cause of action has been pleaded by the respondents in the second eviction petition by claiming arrears of rent not only for the period for which the first eviction petition was filed but also for the subsequent period up to 18/05/2001 cannot be a ground to hold that the second eviction petition was maintainable. The relationship of landlord and tenant between the parties was not established in the earlier proceedings, and the same point is directly and substantially in issue in the second petition, wherein the foundation to claim the arrears of rent is the stand of the respondents petitioner therein that they are the landlords of the petitioner. Herein the findings returned by the rent controller in his order dated 27/01/1998. First, in the first petition have to be held to be findings on merits and having been adjudicated conclusively are final in nature and act as a part of res judicata on the second eviction petition preferred by the respondent's parent. In view of the aforesaid facts and circumstances, this court is of the opinion that the improved order dated 23/07/2002 is not in accordance with law and cannot be sustained. The said order is therefore set aside the quashed. The application filed by the petitioner under Order 7, Rule 11 of the CPC is allowed. It is held that the second eviction petition filed by the respondents under Section 14 (1) A of the Act is liable to be rejected, being barred by the principles of res judicata order accordingly (passage supplied para). Being dissatisfied with the aforesaid order passed by the High Court, the appellants claiming to be the lawful owners and landlord of the property in question have come up before this court by way of the present appeal submission on behalf of the appellants para. The landlord counsel appearing on behalf of the appellants vehemently submitted that the High Court committed a serious error in taking the view that the second eviction petition number 136 of 2001 was not maintainable in law as the same was hit by the principles of res judicata. He would submit that the plaintiff would not have been rejected under the provisions of Order 7, Rule 11 D of the CPC, as the issue of res judicata could be said to be a mixed question of law and fact. He would submit that there is no averment in the plaint of the eviction petition number 136 of 2001 on the basis of which he could be said that the eviction petition is barred by any provisions of law. The learned counsel further submitted that the High Court also committed an error in applying the principles of Rule Order 17, Rule 3 of the CPC as the first order passed by the rent controller dated 27/01/1998 in the first eviction petition was or not on merits, and therefore no finding could be said to have been rendered as regards the relationship of landlord and tenant, which could be said to be binding between the parties in the second eviction petition. In such circumstances referred to above, the learned counsel placed that there being merit in his appeal, the same may be allowed and the impugned order by set aside para. Submissions on behalf of the respondent number 1. The learned counsel appearing for the respondent number 1 on the other hand vehemently opposed to the present appeal by submitting that no error, not to speak of any error of law, could be said to have been committed by the High Court in passing the impugned order para. He would submit that in the first round of litigation, late S. Singh original plaintiff was given sufficient time and opportunities by the rent controller to establish the landlord-tenant relationship. However, S. Singh failed to appear before the court and also failed to lead any evidence in that regard. In such circumstances, the rent controller was justified in dismissing the eviction petition. The learned counsel would submit that the High Court rightly observed that the order dated 27/01/1998 passed by the rent controller in the first round of litigation could be said to be under the provisions of Order 17, Rule 3 of the CPC, and if so, then the finding that the original plaintiff S. Singh was not able to establish the landlord-tenant relationship would be said to be on merits. He would submit that once such finding such come on record, the appellants later in point of time claiming through S. Singh as successors in interest could not have preferred a fresh eviction petition on the very same grounds as the same would be hit by the principles of res judicata. He would submit that the High Court rightly rejected the plaint of the eviction petition under the provisions of Order 7, Rule 11 (D) of the CPC. Stop. Thank you.